Welcome. Let's talk about a very important implied covenant, the implied covenant to protect against drainage. This is that implied promise by the oil and gas companies that when you've leased your land to them, they are going to prevent everyone else from getting all your oil and gas before they've gone ahead and drilled themselves. So it's an important and potentially powerful covenant. So to talk about it, let's talk about the Amico versus Alexander case, which is on page 397 in your texts. And the basic circumstance was the one you can see depicted here, which is that Amico had two leases, one with the Alexanders and then one further up dip, as we say. So these are the down dip leases because they're drawing from deeper in the reservoir on this side, and these are the up dip leases on the top. Now, what would happen normally is that as that oil and gas was extracted, the water level here would rise. It would rise further and further, and at some point, this well here on the Alexander's property would water out. There would be just water, no more oil, and they wouldn't be, they might have to be shut down because they violated a water to oil ratio, or simply they might have to shut down because there's no more oil, so there's no benefit in pumping, and so that would be a problem. Now, what the Alexanders here allege is that Amico had a duty to look to drill another well, even closer to the property line. And the idea is, well, they should be able to drill that well to get that little corner of oil there. Now, of course, all these properties are pulling oil from the shared reservoir, but you might wonder, well, you know, if this was so important to drill this new exception well to get that last corner of oil, why wouldn't Amico do it anyway? They get to keep the vast majority of oil. And there's a couple reasons. One is, of course, yeah, they get to keep the bulk of the oil, but they also have to pay all of the costs. So maybe that's why it's not worth it for them. But here, another reason it might not worth it for them is that they were one of the parties benefiting from the reservoir on other leases because they have these other leases over here. So they might think, you know what, too bad that lease with the Alexanders, that watered out, but that's all right. We are still getting oil from these other properties. And so the court says, no, Amico had a duty to apply for exceptions. Amico said, well, wait a second, you know, these are the conservation rules. They're supposed to protect everybody. Maybe it's with crocodile tears, but they're saying, you know, why don't we just follow the conservation rules in this instance? But the court says, no, you have a duty to apply for exceptions because you have this implied covenant to protect against drainage. This is one of the basic things you're supposed to be protecting your lessor from, which is that other people taking away their oil. On the other hand, court says, no, this is not a situation where punitive damages are appropriate. This is a contract claim. So if it's a normal violation of the contract as opposed to a tort, we're just going to have regular consequential damages. We'll talk in a little bit about what kind of damages those would be. Okay. I think one thing that's interesting about that, and let me just go back to the slide for 1 second, is that this is a particularly tough situation for an oil company. I mean, often oil companies might be less interested in drilling a well to get out just a tiny bit of oil and gas than the royalty owner. Why is that? Again, it's because the oil and gas company pays the cost of drilling. So for an oil and gas company, another well may very well not be worth it. From the perspective of the landowner, the more production, the better, no matter how much it costs to gain that production. Because since the landowner is not paying those normal production costs, everything up to the wellhead, all the drilling, all the fracking, etc., the landowner doesn't care how much it costs. They just say the more oil, the better. And that's why we see so much of a theme to oil and gas law that landowners are saying those lazy oil and gas companies, they don't want to produce oil and gas. And they keep trying to get the oil and gas companies to produce more oil and gas on their land. Maybe that's not the picture of oil and gas companies we have from other areas, but that's a very animating theme for oil and gas law. All right. So covenant to protect against drainage just says the lessee, the oil and gas company, has to act as a reasonably prudent operator to protect the leased premises against drainage. The lessor, they want to recover under the covenant to protect against drainage, has to show there's been substantial drainage of the property by other wells. A prudent operator would have protected them, and so therefore they have damages in terms of lost royalty from that drainage that they're now no longer going to be able to receive because that oil is gone. So some complications. One is situation where, as we described with Amico, it's a common lessee. So you lose oil from one, maybe they're entirely happy with that because it just goes to the neighboring property where they have a lease as well. In fact, there's a great quote on page 407 from your book, A Case from the Eastern District of Illinois, where the judge says, you know, this is one of these common lessee cases where there's oil somewhere else, and when the oil and gas company is trying to justify its decision not to drill another well, the court says, well, the mind is haunted. The mind is haunted by the thought that this oil is going to my neighbor, and it's the same oil and gas company, and so they're still benefiting from it. So that common lessee can, some people say, well, maybe that should switch the burden of proof. So if the oil and gas company is benefiting by somebody else drilling and producing oil off your property because it's actually the same company, well, then you should switch the burden of proof, and the oil and gas company should have to show that they're not improperly draining from this lessor. So a lot of times there's efficiency to being an oil and gas company that's operating lots of neighboring plots, but there can also be legal complications because it may make people look askance at the way you're operating. Are you really operating for the benefit of each individual party or just for yourself? Okay, then the other question is, it has to be what a prudent operator would have done, okay? So you have to show that a prudent operator would have drilled that well. Now, what does that mean? Usually, if the oil and gas company can show, look, it just would have been entirely unprofitable to drill another well, they can get away with not drilling it. But what if you can show, as a lessor, well, they would have made a 5% profit. Is that enough to force that oil and gas company to drill a well? What about a 10% profit? 10% profit is enough for most regulated utilities. Would that be enough for the oil and gas company to drill that well? I can tell you, most oil and gas companies don't consider a project that's only promising a 10% return. But you can think about, it can be hard to show what a reasonable profit is. And then finally, what's the role of conservation laws? We saw that in Amico versus Alexander. Can you say, well, sorry, here's where the field rules say I have to drill, and that's the end of the story? Probably not. There are some cases a duty to apply for an exception, but how much do you have to press against those conservation rules as a prudent operator? Okay, well, let's say you can show a violation of the implied covenant to protect against drainage. What's the measure of your drainage damages? So one way to do it is say measure by the amount of drainage. So you drained off this amount, give me my royalty share of that. Another idea would be, let's go based on if the company had, when it should have, applied for an offset well to get at that last bit of oil, how much would that have produced? Maybe it wouldn't have captured all the drainage, but maybe it would have captured half of it. So you remember sort of that up dip, down dip leases. Here's the lease line. The original well came in like here. Maybe a relief well or an offset well would have come in there. They still might not have gotten that last bit of oil and gas as the level of oil rose. So maybe damages should have just been that little slice in here that the oil and gas company would have produced had it drilled a timely offset well. Another question is, should there be some kind of different damages in that common lessee, same oil and gas company situation? Should there maybe be higher damages, or should they be dependent on the benefit that the oil and gas company received on that other land?